The solicitor argued towards the latter part. He said that what they said in their letter was that we wanted to withdraw support from the MVA government.
Yes.
So he said this in effect was therefore a withdrawal of support to the government.
Let's assume, Manoj. I will assume that against me. That can happen in any situation, Manoj. Any 2 people, 4 people, 7 people, 12 people, 30 people can withdraw support. They may be members of the legislature. That is why the whole purpose, Manoj, of the Constitution, Article 170 onwards, and to only recognize political parties, the whole purpose is that. That's why Kyoto says, Manoj, that you cannot, you don't have any other identity. Integrity of the political party and the political process. That's why. I will accept all that, Manoj. That's exactly the Ayaram Gayaram test. That anybody can walk out.
The difficulty arises in an emerging situation. This is the question that's been troubling. In an emerging situation, suddenly during the process of the existence of the Legislative Assembly, there is this kind of a dissension. Take, for example, this very case. So what is very apparent so far as the House is concerned, 34 have come on to one side.
Right.
This doesn't definitely, there's no material that it reflects what happened outside.
That's right.
There's no doubt about that.
Yes.
But in a situation, perhaps one, is it possible, how does one, let us say the speaker, when such a thing is placed before him, would he also take into account or merely adjourn the case, asking the parties to go back to the election commission and get it proved?
Yes, but that, I was going to come to that. Well, let's forget this case. Let's take a case where people, I don't take for granted what that letter says on the 22nd, that the electorate is unhappy. Your Lordship knows, there's not a single instance of any of them making any statement prior to the 21st of June that anybody is unhappy. This is all their statement made, because they are now sitting in Guwahati and they know what the consequences. And they didn't go to Surat and Guwahati, on the 21st. This must have been pre-arranged, These things don't happen overnight. But be that as it may, I don't want to enter into the politics of it. But your Lordship is right, It is correct, but that these things will happen. But what is to be done? What is to be done is, if you are a faction and you go to the governor will say, I can't recognize you. You want to say you are the political party, Now forget this case. You go to the election commission. You say you are a faction. I am the political party. Supposing you had gone to the election commission and done that, and then attempted to change, no problem. First, the commission would have decided. In the meantime, the disqualification petitions would have been heard. That's the constitutional. And don't connect one with the other. Then the disqualification would have been decided. Then they wouldn't have been able to go to the commission because you're deemed to have given up membership of the party. And forget, so there may be no dispute at all, Why do you say there's a faction in the legislative party? There may be if 2 factions within the political party, each claiming that they are the party. Forget about disqualification. What's the procedure? Go to the election commission. Can the procedure ever be that you claim as a faction of the legislative party to be the political party, get recognition from the governor, topple the government, then go to the commission and say, these are the 36 or 38 members of the legislative party. We are dominant in the legislature. Now we must get the symbol. Cannot be. By any standards of constitutional law. This cannot happen.
What happens in the interregnum?
Sorry?
What happens in the interregnum?
Suppose
the speaker takes a prima facie view and says that go to the election commission and come back to me and tell me who actually is the political party.
No, the speaker will not do that, and with great respect.
Then he proceeds with 10th schedule?
No, yes, he'll proceed
with it. Then all the 34 will be disqualified?
Yes, why not?
No, I'm just asking you.
Yes, but they will be.
So therefore, that's the consequence.
Yes, they will be. Let me tell you, Lord, this is also a very other important aspect of the matter.
With the advent of 10th schedule in a situation like this, where more than 3/4 of the legislators have, let us call it not a split, let's call it a faction in terms of symbols order.
It is a faction.
Symbols order. Let us call it as 3/4
yes.
are in one group.
Yes.
then in which case it's an inevitable consequence that the faction which is in control of the government would have the speaker with them and would disqualify them.
Yes.
There is no other alternative according to
Yeah, there can't be, Malas, for the reason the third paragraph has been deleted. The whole purpose of it is that you cannot have, see, they will still be disqualified for their acts for having voluntarily given up membership of the party.
It was 1/4.
Even if they are the party, Malas,
It was 1/4, Mr. Sibal. That's why I was asking them repeatedly.
1/3.
1/3,
Yes.
right? We are talking of a 3/4 situation.
Doesn't matter, Malas, because 1/3 could have been 2/3 also.
Isn't there a difference between split and overwhelming majority of legislatures?
No, that's not recognized by the 10th schedule, Malas. The 10th schedule doesn't recognize it. Malas, I just wanted to mention one other broad point, Malas, before. If your lordships will allow me to respond to your lordship's query a little later, if your lordships permit me to do that. I just wanted to make one other broad point, Malas. And that is, if my lords look at Article 180, sub-article 1. Your lordship has that. While the office of a speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of the deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. The governor may appoint for the purpose would be on the advice of the council of ministers. And during the absence of the speaker from any sitting of the assembly and deputy speaker, or if he is also absent, such person as may be determined by the rules of the procedure of the assembly.
So
or
one
if no
deals
such
with vacancy, second deals with absence.
So, Maharaj, either way, Maharaj, if both of them are absent or for some reason cannot participate, somebody else will be appointed.
Right.
Right? Now, in this context, look at paragraph 6.2 of the 10th schedule. They have to be read together. It's just another broad point I wanted to make before your lordship. I'll read 6.1. If any question arises as to whether a member of a house has become subject to disqualification under the schedule, the question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and his decision shall be final, provided that where the question which has arisen is as to whether the chairman or the speaker of a house has become subject to disqualification, the question shall be referred for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. So what is it that I am canvassing before your lordships? That there can be no hiatus.
Right.
If there's a deputy speaker against you who have given notice, the disqualification proceedings don't stop. That's my first Maharaj. At the outset, I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, Maharaj, is as Maharaj, the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided Maharaj over the house and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the house is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No, the person elected as the speaker then, or chairing the house, will decide. There is no committee.
Read with 180.
Yes. There is no committee. So therefore, Maharaj, all this not dealt with in Nabam Rebia.
What's the ground for removal of the speaker?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, Maharaj, that notice was an ab initio void.
No, but they can always say that, look, we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Shakhtar and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why Maharaj, he is allowed to be in the house, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in Nabam. So these are very serious questions. That's another broad point I wanted to make, Maharaj, before I proceed.
Yes.
Anyway, now kindly come to the propositions that I have placed before your lordships. Their argument was,
Page 2.
yes, 3 is the respondents have not incurred disqualification under the 10th schedule because their claim is not that there is a split, but that they represent the Shiv Sena. That's their case, which has been decided by the Election Commission in their favor, that there is no distinction between the legislative party and the political party, and the 10th schedule does not stifle the right of the legislatures to dissent. That's their argument. I hope I have encapsulated it accurately. Then next 4, respondents have not incurred disqualification under 2(1)(b) of the 10th schedule because the respondents had appointed their own whip, Shri Bharat Gogavle, on the 21st of June, and they have obeyed the whip issued by Gogavle. The legislature party has the right to appoint the whip, relying on members of Maharashtra Legislative Assembly disqualification on grounds of defection rules. I hope, that's a correct articulation of what they've said. Now, our answer, kindly straight away come to, yes, governor's decision. The respondents contend that it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the assembly, and further contend that by whatever process or means the governor can gather the information that was required, which raises a credible doubt as to the majority of a government in power. In support of this contention, reliance was placed on the law laid down by this Honorable Court in Bomai and in Shivraj. That's their case. It is respectfully submitted that the respondent's contention is misconceived and is based on a misreading of the law in Bomai and Shivraj. It is settled law that the governor's decision to call for a trust vote is subject to judicial review, and the same is liable to be quashed if it is based on extraneous considerations. In Shivraj Chauhan, whilst holding that the exercise of discretion by the governor to call for a floor test is subject to judicial review, this Honorable Court observed that, quote, the court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of power. The exercise of such power is not intended to destabilize or displace a democratically elected government, accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of the satisfaction by the governor is not based on extraneous considerations. That's the heart of the decision. It's not Miller's that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships. Then, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction that the government headed by Uddhav Thackeray had lost the trust of the House on the basis that, and I quote, majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislature party that they intend to exit from the Mahavikas Aghadi government. That's the heart of the matter, Minister. That's the decision of the governor. The 34 of them have come to me, and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkaria Commission, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any 3 people from any party will go to say that now you must call for a floor test.
All right, let's read ahead so that we'll get your formulation.
Yes. Firstly, it is respectfully submitted that the resolution of 34 members of Shiv Sena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Mahavikas Aghadi government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shiv Sena MLAs as demonstrating their intention to exit from the Maha Vikas Aghadi government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shiv Sena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law.